This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why, when parties agree to appraisal, a trial court has no choice but to agree with them, and appraisal becomes a requirement to resolve the extent of a loss. In an insurance dispute stemming from Hurricane Ian, the parties agreed that their case should go to appraisal to determine the extent of the loss, and so advised the United States District Court. When an insurance policy contains an appraisal provision, the right to appraisal is not permissive, but is instead mandatory. So once a demand for appraisal is made, neither party has the right to deny that demand. Like other stipulations about dispute resolution, the court enforces contractual appraisal provisions by a non-dispositive order. Therefore, in a case called Buena, Vista of Deep Creek Condominium Association versus Clear Blue Specialty Insurance Company, the United States District Court for the Middle District of Florida on November 27, 2023, concluded that because appraisal will not dispose of any claims or defenses, the court did not treat the motion as one to compel appraisal as one for summary judgment. And since the parties agreed that appraisal was appropriate, their request was granted. Further, the parties requested a stay during appraisal, which was also granted because the Hurricane Ian scheduling order contemplated such relief if the parties agreed that appraisal was appropriate. Thus, the case is stayed. All deadlines and events in the Hurricane Ian scheduling order were suspended. The parties agreed that the appraisal panel must itemize the awarded damages by coverage to be accompanied by supporting estimate. Though the parties cite no contractual provision that requires such an award, because the parties agreed, their request was granted by the district court. Accordingly, it was ordered, 1, that the joint stipulation for appraisal and stay of the case was granted, and the appraisal panel must itemize the awarded damages by coverage to be accompanied by a supporting estimate. 2, the case was stayed pending appraisal, and the clerk must add a stay flag to the file and administratively close the file. 3, the parties were directed to file a joint report on the status of appraisal on or before February 26, 2024, and every 90 days thereafter until appraisal had ended. And 4, within 15 days of a signed appraisal award, the parties were directed to jointly notify the court of A, what issues, if any, remain for the court to resolve, B, whether the stay needs to be lifted, and C, how this action should proceed, if at all. The appraisal condition of a first-party property policy is an extrajudicial means of resolving disputes between an insurer and an insured about the amount of loss. Since the parties agreed that appraisal was an appropriate manner of resolving that limited dispute, they moved to stay the action in federal court in hopes that the appraisal result will allow the parties to resolve all of their differences. The court understood and issued orders to fulfill the agreement of the parties. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and access to the more than 4,650 blog postings. You can also subscribe to the videos on YouTube and on rumble.com, and if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on Rumble. If you're interested in more detail about insurance, insurance claims, insurance fraud, and insurance law, please consider subscribing for a very small fee to my Substack publications. Thank you for your attention.